Hi again, Attorney Steve Vondran. In this video, we are talking about the civil tort of battery in California. This is California general legal overview. This is not legal advice or a substitute for legal advice. This is a special request. I had one of my YouTubers say, hey, Attorney Steve, why don't you do something about the tort of battery? I need to understand what that is. So let's go, man. I got the jury instructions. We pulled these down off the internet here. These are the instructions the jury will hear in California if you have a battery claim going, and sometimes you're gonna see battery with the tort of assault. Torts are civil wrongs one person commits against another, and assault and battery are what we call ham and eggs. It's like the ham and eggs of law. So you're gonna get, oftentimes you may have both, okay? So without further ado, let's hit it. Okay, these are the CACI, California Civil Jury Instructions, number 1300, if you're looking that up online, okay? So battery, the essential factual elements. These are the things that a plaintiff has to prove to prevail in their case for civil battery, and they need to prove these elements by a preponderance of the evidence, okay? That's the burden of proof, okay? If you can't prove it, then you might as well not even bring it. So here's the tort of battery. 1, defendant touched the plaintiff or caused the name of plaintiff to be touched with the intent to harm or offend him or her. So let's go over that. Let's break that down. First element, that the defendant touched the plaintiff or caused plaintiff to be touched. Okay, so that could be walking up to somebody and pushing them. Obviously, you're touching them. You're making contact. This is the defendant making contact with the plaintiff. That's pushing them. You're touching them. Or causing the plaintiff to be touched. This could be picking up a brick and throwing it at a plaintiff and hitting somebody in the face or something. You're causing them to be touched. With the intent to harm or offend. So this is what we call an intentional tort, as compared with negligence. Negligence is you're not exercising the standard of care to protect somebody against bodily harm. The intentional torts require the intent to harm or cause damage. In this case, it's the intent to harm or offend. So obviously, if you're picking up a brick and throwing it at somebody or shooting an arrow at somebody, you're intending to harm them, okay? But also it could be the intent to offend a person, okay? So what could that be? I don't know, throwing an egg at them, spitting on them, obviously you're intending to cause that bodily contact. That could be intending to be offensive. That could be intending to harm them. So either one of those types of things are going to qualify, okay? Now, it's often been said, not awful, it's often been said, that if you intend to commit an assault or intend to commit a battery, that is sufficient for the tort. So in other words, an assault, just so you understand the difference, sometimes you hear, well, that's assault and battery. Okay, it's like sounds like a rock band or something. Assault and battery. So, but the assault is where you intend to put someone in imminent apprehension of a harmful or offensive bodily contact. So in other words, that's where I go, I pick up the brick and I go, ooh, yeah, and somebody imminently believes they're going to be harmed by that brick. That's the intent to commit an assault. That is sufficient under California jury instructions for the battery or the intent to commit a battery. So it gets a little confusing, but just know if somebody's intending to cause a harmful or offensive contact, intending to cause imminent apprehension, and let's say, whoop, the brick accidentally hits you in the face, well, that's enough, okay? So that's element number 1. You got all that? Number 2, that the plaintiff did not consent to the touching, okay? So it's a defense. It's a defense under the law. If the plaintiff consented to the touching and signed a waiver, I hereby agree. Like a doctor, you go in and you get something done with a doctor, and you say, I hereby consent to this. Okay, we are consenting to a certain amount of touching, so that's going to be sufficient. And that's going to be a defense. So always be thinking, did I consent to this? That's element number 2. Element number 3 of 4, okay? That plaintiff was harmed or offended. So you have to show as a plaintiff that you were either harmed or offended. Now, harmed can be all kinds of harms. It could be, this is a dignitary tort. So if your sensibilities, if you were embarrassed or, emotionally harmed, physically harmed, if you suffered bruises, if you got a big bruise on your forehead, like a baseball coming out of your head because the guy hit, obviously that's harm. You can seek compensatory damages for those things. But also if you were offended, in other words, if somebody's throwing an egg at you at your wedding or something, I mean, think about the embarrassment level of that. You can seek those kinds of damages. If it was malicious, oppressive, if it was something really shocking and just, you can seek punitive damages because this is not something arising out of a contract. So you could potentially seek punitive damages. So number 3 element is that the plaintiff was harmed, and 4, that a reasonable person in the plaintiff's position would have been similarly harmed. Okay, so that's the big question, because so if somebody comes up to you and pokes you on the shoulder at a concert, and you go, "Oh my God, he touched me! I can't believe it! All my friends saw this person touch me." That's not going to work. It has to be something that would offend the reasonable person in your situation, the reasonable person. And we're going to do a whole nother video on this reasonable person. What is the reasonable person? It's something to think about. So those are your 4 essential elements. Did you capture them? Intentional, harmful, or offensive contact, no consent, harm, and the reasonable person would have so suffered the same type of harm. Okay, there you have it. If you could prove those 4 things, you might be able to recover for your damages, for your different types of damages against the wrongdoer. Again, there may be an assault in here. There may be a battery. Now, obviously, if you hit somebody with a brick, that would be not only a civil tort, but also the crime of tort. So you bar examiner takers, you're going to take that bar exam. You're always looking, my bar exam tip is you're always looking on every fact pattern for that battery, that assault, and you want to talk about the civil side of it. You want to talk about the criminal side of it because, of course, assault and battery, a lot of people know, is a crime. So a prosecutor may take interest in it. You're throwing a brick at someone or coming up to somebody with a knife and holding it in their face like that, yeah, you could face assault and battery charges, okay? So be thinking about that. Now, we have here that, you don't actually need a bruise to recover. I'm going to read just one of the jury instructions. It says, "It has long been established both in tort and in criminal law that the least touching may constitute a battery." The least touching, in other words, force against the person is enough. It need not be violent or severe, so bear that in mind. It need not cause bodily harm or even pain, and it need not leave a mark. So bear these things in mind. So this is, again, a dignitary tort. It's a tort to the dignity of another person. So, be careful when you're touching people. What can you say? Exceeding the scope can also still cause a battery. In other words, you say, well, he consented. It's like when you go to a doctor and you say, well, I'm consenting for you to, remove this mole off my ear. And the doctor's removing the mole and decides that they're going to go down and, perform back surgery, cut a slice in your back. Well, I didn't consent to that. I consented to this. I didn't consent to that. So now you're exceeding the scope of consent. So exceeding the scope of consent can still get you a battery. Okay, last but not least, transferred intent. This is for you bar examiner takers wanting the Attorney Steve tips. Transferred intent, don't miss this. This is a big point to catch. In other words, if I'm intending to hit Paul with a brick and instead I miss and I hit Sue with the brick, who's got the cause of action against me? The defendant. Who's got the cause of action? If you said both, you got it. Paul would have an assault against me because I intended to cause him imminent, harmful, offensive bodily contact, but missed, and I hit Sue. Sue's got the battery. I hit Sue. I intended to hit him. That intent is transferred over to Sue. If you pick that up on the bar exam, baby, you are getting big points. You are pushing yourself to the top. You're giving yourself a chance to get that ding, ding, the golden ticket. Okay, so that's it. I mean, that's a general legal overview of the tort, the civil tort of battery in the state of California. If you have suffered a battery, you need a litigation attorney. Who are you going to call? That's what I thought. Okay, Attorney Steve Vondrand, thank you for listening. If you need more information, go check out our website at attorneysteve.com. And we're always happy to help you out. If there's any other videos you want to see, let us know. You got some comments, put them down below. Let's hear what you got to say. Shout out. And feel free to share this video on your social media networks. Okay, Attorney Steve, we'll see you again. I got to get back to work. Wife's calling. See you later.